Good afternoon. My name is Autumn Williams, and I'm a staff attorney with Lone Star Legal Aid. I work in the Beaumont branch office, which services Hardin, Jefferson, Liberty, and Orange counties. I am joined today by Tia Banks, lead case manager with Legacy Community Development Corporation, better known as Legacy CDC, and by Barbara McIntyre, executive director of Liberty County Long-Term Recovery Committee. Now, before we start today, I want to let you know that this presentation is intended to serve as legal information and does not replace legal advice. You can contact Lone Star Legal Aid at 1-800-733-8394 or go to www.lonestarlegal.org for more information or to apply for legal assistance. Lone Star Legal Aid does not discriminate on the basis of race, color, religion, gender expression, sexual orientation, age, national origin, ancestry, disability, marital status, or military status in any of its activities or operations. During this presentation, if you have any questions, please post your questions in the chat box or the comment section. We have someone monitoring that and we'll address questions at the end of the presentation. Today, the focus of the presentation is on tenant rights during eviction and abating your eviction, which is currently still an option until September 1st. But first, I want to introduce our community partners and learn about how they serve our communities. First, let's give a warm welcome to Tia Banks, lead case manager with Legacy CDC. Tia, thank you so much for joining us today. Please tell us more about Legacy CDC. What do you do? Who do you serve? And how does one access your services?
Yes, we want to thank you for having us today. I'm going to go ahead and share my screen. All right, so I want to first start off by thanking Vivian Ballou for allowing me to be here today. She's our executive director. Just a little brief about the program, our Legacy CDC in general. We are a nonprofit organization and we're here to serve you guys. So if you guys need anything, please contact us and we are more than welcome to help you with any needs that you may have. The first program I'm going to talk about is our ERA Jefferson County program. This program specifically helps with people that are back rent, back utilities, as well as forward utilities, as long as you don't exceed that 18-month cap between TRR and ERAP1 Jefferson County. This program, you can apply online. We do prefer that you do apply online because it's a lot of people that are applying who are in need due to evictions. Right now, we're working through evictions first before we get to people who don't have evictions, just because we don't want those people to be evicted. But if you guys have any questions, you guys can give us a call and we can gladly send you guys the link via text or email, whatever is preferred by you guys. And yeah, that's the ERAP Jefferson County program. The other program that we have is our ERAP HHS program. This program is more so leaning towards deposits and homelessness. You don't necessarily have to be homeless. You could be living with a family member and just need help getting on your feet. This program can put you in a hotel for about a week. We help with deposits, whether it be rental deposits, utility deposits. We can help you with food, credit repair. We can help you with career readiness. If you don't have a job, we can help you with that. We can help with mental health counseling. Yeah, this program is a great program for people who are trying to get on their feet. Our income limits are pretty high right now. That they've raised them this year. So if you don't think you income qualify, you probably do because they are pretty high. But yeah, those are the two programs I am going to hit on today. The other program we have is home ownership, and you can call about that one and they can help you.
Okay, great. Thank you, Tia. Legacy's commitment to this area and servicing a low-income and homeless population is greatly valued and appreciated. So everyone, please stay tuned to this presentation because later on I will be discussing how you can ask the court to abate or pause an eviction if you have submitted an application for rental assistance to Legacy or to a similar rental assistance program. Now, next, let's give a warm welcome to Barbara McIntyre, Executive Director of Liberty County Long-Term Recovery Committee. Barbara, thank you for joining us today. Can you please tell us more about Liberty County Long-Term Recovery Committee and how it services our community?
Yes, thank you so much for this opportunity, Autumn. It has been great working with you going back and forth. We are a LTRC, which once the disaster is over and families are able to get back to their homes, we come in and help with home repairs and bringing in resources. We basically focus on veterans, disabled, and senior citizens. We know that there's so many issues in communities, and so we try to target the most vulnerable population where there is not very many resources.
Great. Well, our area has experienced several major disasters, some of which were classified as national disasters, and FEMA provided some help, but others that were just as devastating to us were not deemed as national disasters, and assistance was extremely limited. I mean, specifically, what are some of the disasters that we have experienced where Liberty County Long-Term Recovery Committee was able to provide assistance to those in need?
Well, because we are off the beaten path and not near Harris County, we were declared late in the game with Harris County, with Harvey, as well as Imelda and the ice storm. But the 2015 floods, the 2016 floods, which I think was called the tax flood, that Houston was actually a part of. And so we got some recognition, but we have yet to receive any funding. And because of a small community and not being visible, not having a lot of media in our community, we are continuing to struggle and try to find resources outside of our community to help our vulnerable population. So we're still recovering with about 77 residents that we're trying to recover from Harvey. Somewhere around 45 that we're still trying to recover from Imelda, and the ice storm, we're somewhere around 65 that we're still trying to do plumbing. So when something is declared and you don't come up with the right numbers of people and homes being damaged, then we don't get federal funding, and most of the time it's most.
Yeah. Well, I just want to make a quick note that if you are renting and a disaster hits and your rental unit is damaged and your landlord is not fixing the damage, you do have the right to request repairs. You also may have the right to terminate your lease if the rental unit is not habitable, which happens many times when it's affected by a disaster. However, the rules are a little different during times of disaster. And it's not something I'm really discussing today, but it's something I wanted to point out, because if you find yourself in this situation, you can apply for assistance with Lone Star Legal Aid. You can also find more information about your rights, how to request repairs, how to terminate your lease, and how to get assistance from the court if you need by visiting the Texas Law Help website, which I'll discuss later on in this presentation. But Barbara, what are some of the qualifications for getting assistance from Liberty County Long-Term Recovery Committee?
Okay, most of our clients have to be seniors in most cases, or disabled, or a veteran. And so we want to take care of our veteran population for sure. And so there's no age restriction on that. But you must be a homeowner. We try to find resources in our county that help people who are not homeowners, but you must be a homeowner. You must have lived in that property at the time of the disaster, and you must supply all the documentation that is requested, ID, income information, in order for us to qualify you.
Now, if someone needs assistance and they want to apply for help from Liberty County Long-Term Recovery Committee, how do they apply for your services?
We have several options. You can use my direct number, which is 281-687-6947. And then at that point, we will get you an application email or mailed out to you, or you can pick it up at one of our locations that we have partners. The second one is our email address is Liberty Texas spelled out LTRC@gmail.com. We are now in the process as we move forward of getting our webpage up and running. We found a company that works with a nonprofit that fits our budget, and we're going to have a web page out soon. So it's coming.
Yes. Well, and I'll talk a little bit more about this in a minute, but in the comments, we are putting a link to your Facebook page. But in the future, I'm sure there will be a link on that Facebook page, or if you need their assistance, you can always, once that website is up and running, you can Google Liberty County Long-Term Recovery, Texas, and your new website should come up. So we'll be looking out for that and excited to see that coming around. So, I mean, thank you so much for telling us about what you do for our community. But now I want to ask, how can our community help you? I mean, resources are in short supply right now, but the more resources you have, the more you can help others. So if there are other organizations watching this presentation and they want to help you assist our community, please let us know what needs you have and what type of organizations you are looking to partner with.
Yes, we are looking to partner with anyone that wants to serve homebound people who are at risk, vulnerable population with low income. What we're dealing with right now with our homeless population that Liberty Long-Term Recovery cannot do anything about, but our veterans and our people who have withstand a disaster, a lot of them cannot live in these homes. So we're in need of air conditions for homes because of the repair that's needed that we have not been able to get to them. Portable air conditions. We're looking for volunteers that can come in and spend some time with doing some repairs so that we don't have to spend so much money on labor because after the ice storm, the material has gone skyrocket. And so trying to make our money stretch as far as possible, getting materials in. So plumbers, electricians, all of those organizations that can volunteer to help our organization. And because we are a nonprofit organization, anyone who has a heart for people that want to come on and learn how to work and learn compassion for community and volunteer to get out in the community and spread the word that we are here to help. And make sure that we're taking care of our brothers and being our brother's keeper.
Great, great. Also, if someone comes in and asks or applies with you guys and asks for help because they can't pay your rent, how have you been assisting them?
Well, we have been working with Endeavors, and Endeavors has extended funding for the ones that's in the program till September. They're taking applications, but they're running out of funds. And so at this point, we are calling around to our churches, and our churches are strapped for funding because COVID hit us really hard and people still not back to work. So we are looking for resources and someone to partner with that will come in and help with rental assistance in our community because we just have no place to put people as is because we have such a shortage of rental property. And so to have these people living on the street is really hard. So if there's any funding out there to assist, please call me 281-687-6947.
Well, thank you, Barbara. Liberty County Long-Term Recovery Committee's commitment to Liberty County and servicing the disabled, the senior, the military veteran, and homeless population is so greatly valued and appreciated. Thank you. And as far as any contact information for both Legacy CDC and Liberty County Long-Term Recovery Committee, that information as far as phone numbers, emails, websites, links to the portals. That is all going to be included in the comment section. So if it's not already there, keep an eye out and check that out, because these are some great resources we have in our area. And if anyone out there can further help these guys continue to do what they're doing, definitely give them a call, let them know, because we can all use all the help we can get. All right, so next I want to give you some more information about Lone Star Legal Aid. We do have a PowerPoint. However, I am not going to be the one putting it up. Miss Ashley is going to help me with that. All right, great. Here we go. All right, so Lone Star Legal Aid, we have been servicing low-income Texans since 1948. Next slide. So Lone Star Legal Aid actually serves 72 counties by providing eligible Texans free advocacy, legal representation, and community education that ensures equal access to justice. Next slide. Again, we service 76 counties. We have 14 branch offices, and based on recent census information, over 2 million people are eligible for our services. And in 2019, Lone Star Legal Aid completed over 19,000 legal cases, which benefited nearly 45,000 people. Next slide. And this is just a limited list of some of the areas that we help with. There's going to be another list here in a moment, but we do help with housing, healthcare, consumer. We help with all kinds of needs, disaster relief. All kinds of areas. Next slide. And one of our priorities is providing stable housing and helping in any way we can to help stabilize housing. And we do that by providing assistance to tenants facing eviction. Next slide. And we only service low-income individuals. A lot of the times people apply for our services and they are over income, but you never know unless you try. So I would definitely recommend, if you need assistance and you're having trouble finding assistance, give us a call and apply. Next slide. Here's a list of areas that we help with. I mean, we help with everything from consumer issues to employment. We help with family law, such as divorces and custody cases. We help with healthcare, such as Medicaid cases. We also help quite a deal with housing. We can assist with juvenile issues, neighborhood problems, public education, financial assistance, public benefits, and expungements and non-disclosures. But again, this is not an exhaustive list. The important thing to remember is we do not assist with criminal matters. We only assist with civil matters. Next slide. And if you want to apply for assistance, you can do so 24 hours a day, 7 days a week by logging on to www.lonestarlegal.org. And if you don't have access to the internet, or if you just like a little phone time, you can always give us a call at 1-800-733-8394, Monday through Friday during regular business hours. Next slide. And here's a list of some of our branch offices. We have 14. You'll notice Beaumont's at the top, and I like to think that's because we're the best. But I hear, other people say it's because it's alphabetical, but I still like to say it's because we're the best. Next slide. Here's the remainder of our offices. See, we are we are one of 3 legal aid organizations that cover the state of Texas. Next slide. Here's some information about our social media. I mean, we are online. We are on Facebook. We are on Twitter. We are on YouTube. We are on several different social media platforms. Next slide. So if you'd like to apply for our assistance, please feel free to visit us online or give us a call. All right. All right. So now I want to take this opportunity to give some legal information on tenants' rights during an eviction. Also talk about the eviction process and how you can abate your case if an eviction is filed against you for non-payment of rent while you are in the process of applying for rental assistance. Now, there's a lot of information I could give today regarding tenants' rights during an eviction and the process itself, but today I'm going to simplify and I'm going to focus on what, in my experience as a legal aid attorney in the Beaumont area, are where there's either misunderstanding or tenants are not aware of their rights. So in the comment section, there either is or will be a link for Texas Law Help to a tenants' rights handbook. And that was produced and distributed as a public service by the Texas Young Lawyers Associations and the State Bar of Texas. Now, it doesn't have everything, but it's a great resource, and I encourage all tenants to read through it. You're not going to know about your rights as a tenant unless you look into it and you investigate it. And this handbook is a great way to become informed. Also, I want to encourage you to utilize the Texas Law Help website. It's a great resource regarding civil legal information in Texas. The site is managed by Texas Legal Services Center and is written and developed by licensed attorneys. The legal information, of course, is specific to the state of Texas. And again, it is a great resource. And if you're looking at educating yourself about legal issues, it's a great place to go. And you can also find the link to the Texas Law Help search engine in the comments section. So I get a lot of questions and calls about the eviction process, and it's clear to me that many tenants out there are not aware of the process or their rights during the process. The most common misconception I hear is regarding when is a tenant legally obligated to vacate a rental unit. Now, I want to be very clear. A tenant is not legally obligated to vacate a rental unit until a writ of possession has been executed. Now, I'm going to explain a writ of possession and how it's issued, how it's executed shortly. But again, I want to be clear, until a constable comes and physically removes the tenant actually still has the legal right to be in the rental unit. So if at all possible, you never want to get to the point of a writ of possession. I mean, it is not a fun experience. But again, I just want people to know they're not legally obligated to leave and vacate until that happens. A lot of people think that they have to legally or that they are evicted before that. And so I want to let you know what your rights are. Now, it's not when a notice to vacate is put on your door. It's not when an eviction case is filed. It's not even when you lose an eviction court. It's when the constable executes a writ of possession. And again, we'll talk about when that's going to happen kind of near the end because there's a lot more to talk about before. So I'm also asked questions all the time about what can a landlord do if a tenant is behind on rent. Now, there are some landlords in our area who allegedly tell tenants that they are going to remove all their property if the rent is not paid. Now, a landlord cannot remove your possessions and put them outside your rental unit unless a writ of possession has been issued. There are some cases where if they can get a lien, they can take certain property, but they're not going to leave it outside your rental unit at that point. So if this happens in most cases, it is illegal eviction. And the illegal eviction, sorry. You do have recourse against the landlords if this happens. You can sue them for damages. You can file for a writ of re-entry to get back in if you can't gain access to the rental unit, which usually is the situation in most of these cases. And I'm going to discuss that more in a moment. So for more information on suing the landlord for damages when something like this happens, I suggest either applying for assistance with Lone Star Legal Aid or going to Texas Law Help website and type "sue in small claims court" in the search box. Also, please note, if you are low income, you can get your court fees and filing fees waived if you qualify, so that you're basically filing for free. More information is available on Texas Law Help if you search for "file for free." That's the easiest way to search it. You can find it searching other things, but I usually just type in "file for free" to pull up that information. So there are many tenants out there who are afraid that their landlord will lock them out. I get asked a lot of questions about, can a landlord change the locks? And it surprises many tenants when I tell them, yes, a landlord can change your locks. The Texas Property Code specifically states that a landlord can change your locks if they need to make bona fide repairs, if there's a construction issue, or if there is an emergency. A landlord can also change your locks if you are behind on rent. However, if they change your locks because you're behind on rent, they have to leave a note on your door. So what does this note have to say? It has to, 1, notify you that they changed your locks. 2, it has to state where there is an on-site location where the tenant may go 24 hours a day to get a new key, or a telephone number the tenant can call 24 hours a day and have a new key delivered within 2 hours of calling. Number 3, that notice must also state that the fact that a landlord must provide a new key to the tenant regardless of the hour and regardless if you have paid past due rent or not. So again, let me be clear. If a landlord changes your locks and you have not been legally evicted and you are not out, they have to provide you with a new key, even if you are still behind on rent. And I don't care what your landlord tells you, that is the rule. All right. And number 4 on the notice, it has to state the amount of rent and other charges that are due. So what if your landlord locks you out, but he doesn't provide you with the notice that I just described? I recommend calling them and asking for a key. If they refuse, you can file what's called a writ of reentry. And you can file this for free if you're low income, and you file a statement of inability to pay court costs, which waives your court fees and filing fees. So I'm not going to go into specifics about this because, again, the focus today is on tenants' rights, and I'm discussing your right to get a new key if the locks are changed. So if you're locked out and your landlord refuses to give you a key, you can apply for assistance from Lone Star Legal Aid. Also, more information about a writ of reentry, including forms to fill out and more information about getting your court cost and filing fees waived, in other words, filing for free, can be found on Texas Law Help. In the search engine, type in a writ of reentry or lockout, and then click on the corresponding link. So, what does a landlord have to do to legally evict you and force you to leave? They have to legally evict you. The first step in the eviction process is the landlord has to deliver a notice to vacate. Now, in some cases, the landlord will have to officially terminate the lease first, but due to timing, I'm not going to go into a lot of detail about that. So, what is a notice to vacate and how does the landlord deliver it to you? A notice to vacate is a written notice where the landlord demands possession. In this notice, the landlord has to clearly tell you to vacate and when to vacate. In most cases, your landlord must give you 3 days to vacate. However, it could be more or less depending on what you agreed to in your written lease. So be sure to check your lease. The notice can be hand delivered to you or anyone in your rental unit over the age of 16. It can be posted inside your main entry door, or in other words, your front door. In some cases, it can be posted on the outside of your main entry door. However, there are very specific rules if posted on the outside of your door. It can also be mailed, but if the mail is the only method of delivery, you might actually get some extra times due to something called a mailbox rule. So if you receive a notice to vacate and it is attached to your door or stuck in your door in any way, I recommend taking a picture of where it is before removing it. And the reason is, if it wasn't delivered correctly and you're able to use that as a defense at the eviction hearing, you're going to have proof other than your testimony. And a lot of times that is really important. So a notice to vacate has been delivered. Then your landlord must wait for the time period in the notice to expire before filing the eviction in court. If your landlord files for eviction before the time in the notice expires, you may be able to use that as a defense at the eviction hearing. So, notice to vacate filed, cases filed, notice to vacate's delivered. The time is expired. It's filed in JP court or Justice of the Peace court in the area where your rental unit is located. What's going to happen next? A hearing will be set and you will get a notice of hearing. That notice will come from a constable or another process server. Now, I want to tell you, you cannot avoid an eviction by avoiding the constable or process server. It doesn't work that way. If you do not answer your door, or if the constable is never able to catch you at home, what's going to happen is the constable is going to ask the court for permission to post the notice on your door, and the court's going to approve it, and service is going to be complete. Next step, eviction hearing. Now, I want to warn you, if you do not show up for the eviction hearing and your landlord does show up, the JP or Justice of the Peace will issue a default judgment. In other words, you will get evicted even if you do not show up. If you have already vacated and you don't show up at the hearing, you could be evicted even though you are no longer there. That is why it is very important to show up at the hearing. If a hearing has been set, even if you have vacated. If you have moved out, you can argue that the hearing, or you could argue at the hearing, that possession is no longer at issue because you're no longer there. A JP may still award your landlord a monetary judgment for unpaid rent and court costs, but if possession is not at issue, then the JP should not evict you or award possession to the landlord. So at the hearing, you can prevent defenses. Now, there are many defenses you may have, but I'm not going to discuss them all in detail. I've already mentioned a few, such as the notice to vacate did not get properly delivered. The landlord filed before the time in the notice to vacate expired. Possession's no longer at issue because you moved out. But I'm not going to go through other defenses at this time because I'm sure everyone doesn't want to be here all day, right? However, I am going to say that the inability to pay your rent because you don't have the money is not a viable defense. It may have worked during times of COVID because of all the federal rules that were coming down, like the halt on evictions and things like that. But if you're not able to pay your rent because let's say you're laid off, let's say you've had medical issues, let's say life has just thrown you a whole bunch of curveballs. If you don't have the money to pay rent, and that's why you didn't pay rent, you're going to be evicted. Because again, that is not a viable defense, not having the money. I mean, you could still tell the judge about your situation, but in the end, you are going to be evicted. So if you're applying for rental assistance, you can ask the court to abate your case, which we'll talk about in a moment. So let's say you're successful at the hearing. Let's say you have some defense. Let's say something wasn't delivered right, and you're not evicted. But just remember, it may not be over. If the case was found in your favor because the landlord didn't follow the process or failed to prove their case, your landlord could walk out of there and just refile the eviction and you'll have to do it all over again. They may deliver a proper notice to vacate, then wait the amount of time and then refile it. They may learn their lesson and be successful the second time. So if they want you out, they may keep trying and be successful, especially if you're on behind on rent because you can't catch up, okay? So don't get cocky because you won once. Be proactive. Utilize your time. That way, if they try again and they are successful, hopefully you'll be able to find or already be in alternative housing so that you won't become homeless. But let's assume you are evicted. If you are evicted, you have 5 days to either vacate or appeal. And let's see here. I think this is a little backwards on the camera, but I wanted to show you how to count dates. Okay, you have 5 days. Some JPs, especially in rural areas, may tell you have less time, but the rules are very specific. You have 5 days to appeal. So let's say you are evicted on July 18th, which is a Monday. All right, you count forward 5 days. You do not count the day you were evicted. So counting forward 1, 2, 3, 4, 5. Let's say you land on a day when the court's not in session, like a weekend or a holiday. What do? You go to the next court date, which is going to be the following Monday. That is your deadline to file your appeal or to vacate. Now, let's say you're evicted on the 20th on a Wednesday. Count forward 5 days. 1, 2, 3, 4, 5. You have the same deadline. So sometimes you're going to get a few extra days because of weekends or holidays. Sometimes you're not. So also, if the court closes before 5 p.m. on your deadline date, you might actually get another day. But you've got to ask the questions. You've got to ask what the procedures are. You got to know your rights. Don't assume you're going to get another day. So if you choose to vacate, please note that the eviction judgment will become final. What does that mean? If you're asked by future prospective landlords if you have ever been evicted, you have to tell them yes. A final eviction judgment may prevent you from obtaining housing in the future, and you may not be awarded housing subsidiary assistance in the future because you have an eviction on your record. So if you choose to appeal, please note that if you miss your appeal deadline, you are out of options. So it is vital, if you are going to fight the eviction, that you will file the appeal on time. There may be a few situations where that's not the case, but for the most part, yes, if you miss your appeal date, there are not options. So it is vital, if you are going to fight the eviction, that you file the appeal on time. No room for excuses. So if you miss the deadline because you wait till the last day and you got a flat tire, or traffic was horrendous, or you became sick, you are not going to be given more time. I mean, you can always call the court and ask, but the answer will most likely be no. Just please remember that, and be sure you always file on time. If not, you're going to run out of options. So a few other highlights about the eviction appeal. If you are low income, you may be able to file for free, or you have your fees waived by filing a statement of inability. It's not really filing for free, it's waiving your fees, but it's like you're filing for free. If you're evicted for non-payment of rent, you are going to have to pay money to the court to be held by the court in the court registry until the case is resolved. There are reasons for that, but I'm not really going to go into that. But I just want you to know, you will have to pay 1 month's rent within 5 days from the day you file the appeal. And you count your days the same way we were counting our days for the appeal deadline. Okay. If you fail to make this payment and the JP or Justice of the Peace has not sent your case to the appeal court, then your appeal is not complete and your landlord can ask for a writ of possession and your eviction judgment becomes final. You also have to keep current with rent if you are filing an appeal for non-payment of rents. Okay, what that means is that if your rent comes due on the first day of the month and the first day of the month rolls around while your appeal is still pending, you have to make another payment of 1 month's rent to the court. Now, if you're appealing your case and you're evicted for something other than non-payment of rent, keep paying your rent. If you don't, your landlord's going to have another grounds to evict you, and that's called you didn't pay your rent. So be careful about that. But if it's for non-payment of rent, instead of paying rent twice, once to your landlord, once to the court, be sure you put that payment into the court, and the court will hold it and will not disperse it until the case is resolved. And sometimes it means you make one payment. Sometimes it means you make a payment and 2 days later, another payment is due. So timing is everything. Check your calendars, count for the dates, know what the rules are, know what the requirements are, and keep up with them. Okay, so you appeal, and if applicable, you pay into the court registry. The case gets sent up to the county court at law for your appeal hearing. A hearing is set and you're notified of the date and time, and you get another chance to argue your case. And during this time, you get to stay in the unit unless there's been a possession bond. But again, we don't have a lot of time for that. So if you want more information on a possession bond, you can always go to texaslawhelp.org, Google it, or Google it and get more information about it. But I would recommend texaslawhelp.org. All right, so let's say, and of course, if you lose at county court at law, you can appeal and there's more information there, but a lot of people don't get to that point. So I'm just giving some basic information. There's a lot more, but I'm again trying to keep the information down a little bit. Now, if you choose to do nothing, you do not vacate, you do not appeal. What can happen is your landlord can ask for a writ of possession to be issued. So in other words, on the day that everything is due, either vacating or appeal, if you do not vacate or appeal on that date, the very next day that the court is in session, your landlord can go down there and pay the fees and ask for that writ of possession to be issued. So remember what I said earlier, that this is the point where you are legally obligated to leave. So if a writ is issued and executed, you no longer have the legal right to be in the rental units. So after your deadline expires, if you haven't vacated, you haven't filed an appeal, your landlord again goes up to the JP, pays for the writ of possession. The JP must issue the writ. And what that means is they issue it and they give it to the constable. Now at that point, the constable takes it and goes and puts a written warning on your front door of your rental unit, notifying you that the writ has been issued and the constable will return at a later date to execute it. Now, the constable has to give you at least 24 hours. The constable cannot execute the writ if it's raining, sleeting, or snowing. But how often does it sleet, snow down here in Southeast Texas, right? When it is executed, the constable will tell you to leave if you are still there. If you do not, the constable will physically remove you. The constable will tell your landlord that they now have possession of the rental unit, and the constable will either instruct the tenant, the landlord, or the landlord's representatives to remove the personal property and put it outside the rental unit. So if you're not there, your property is going to be put outside where others may take it, where it could be ultimately damaged or destroyed by the weather, where you could lose it. And again, you never want to get to this point, if at all possible, but this is the moment when you are required by law to vacate and you no longer have the right to be in the rental units. So that is the eviction process. Again, these are just some highlights. I'm not covering everything. If you have any questions, please post them in the chat. So now I want to briefly discuss the abatement process. Now, abating an eviction is not really something that was done before COVID, all right? There may be orders in the future to allow for abatement of eviction, but don't count on it. I mean, we don't know if there's going to be another pandemic. We don't know what's going to happen in the future. I mean, technically, there could be more situations like this, but again, don't count on it. Always be able to, or, always try to be on top of all this. Currently, you can ask for abatement until September 1st, 2022, if you meet certain qualifications. This deadline could be extended, but it's doubtful because it's already been extended multiple times. And a lot of these rent relief programs are starting to run out of money, or have already ran out of money. Okay. So, a lot of attorneys are saying, we don't think it's going to be extended again. It may not. I'm just trying to say, don't count on it. Okay. But stay informed, because if it is extended, the information is going to be on texaslawhelp.org, and it's great information to have. So please check out the comment section for a link to the Texas Law Help page about abatement. Now, this link has helpful legal information. And if you click on the link and scroll all the way to the bottom of the page, you will see links for the document templates that you can actually use to ask the court for an abatement. Now, the 53rd emergency order by the Texas Supreme Court, which was originally the 44th emergency order, but it has been extended a few times since first issued. What this does is it helps tenants who have been sued for eviction due to non-payment of rent. Basically, if you're behind on rent and you're trying to get your rent paid by Legacy CDC, Texas Rent Relief, Endeavors, or some other rent relief program, you can ask the JP or Justice of the Peace to abate or pause your eviction and seal the case record so that future landlords will not be able to see that the eviction was even filed. So, who can ask for an abatement? Now, if your landlord applies for rent relief, or if your landlord participates in your application for rent relief, or if your landlord submits any information or documentation to receive payment as part of a rent relief program, you can ask for abatements. If you have any evidence that any of these have occurred, bring that evidence to the eviction hearing. If you have not applied on the day of the hearing for these type of services, and your landlord says, hey, yeah, I agree, I want to participate because I want to get paid, then you can also ask the court to abate if you're both saying, yes, we want this opportunity to apply for resources. So let's assume the judge abates your case. What happens next? The judge delays the case for 60 days, seals the case records. If you have not applied for rental assistance, so if you came in and everyone agreed, get that application in as soon as possible. Now, during the 60-day period, if the application is denied, canceled, or withdrawn, your landlord can ask to reinstate the case. And what will happen if your landlord asks to reinstate the case is the judge will set a new eviction hearing within 21 days. You will get notice of it, and the judge will unseal the records. So if rent is paid, your landlord can notify the court and ask the case is dismissed. If the case is not reinstated within the 60-day period, the judge must dismiss the case. So if your landlord just doesn't do anything after that, what's going to happen is the judge should dismiss, or you can ask the judge to dismiss it because the 60 days have expired. Again, more information on that is in texaslawhelp.org website. And of course, you can always contact Lone Star Legal Aid for assistance. So again, these are just some of the highlights on the eviction process and about abating your eviction, which is still an option until September 1st, 2022. For more information on how to apply for Lone Star Legal Aid and or getting more information on Texas Law Help, again, check out the comment section, and that information is there. So I want to see if there are any questions. All right, it doesn't look like there's any questions at this time, but I want to let everybody know that this recording will be available for replay on Facebook and also on the YouTube channel, which is youtube.com/lstarlegal. And I believe the YouTube channel link will also be in the comments section. So let's see. And again, I'm just trying to toggle all my little screens. All right, since there aren't any questions, again, if you missed anything, I would definitely recommend checking out the comment section or replaying the video, because I know I went through a lot of information, and sometimes people do tell me I talk a little fast, but please feel free to check that out. I want to again thank our community partners for joining us today. If you're interested in applying for assistance with either Legacy CDC or Liberty County Long-Term Recovery Committee, their contact information again is included in the comment section. I also wanted to give a special thank you to Sarah Frazier, who helped organize this event and was instrumental in getting Lone Star Legal Aid Legacy CDC, and Liberty County Long-Term Recovery Committee together so that all of this wonderful information could be presented to you today. Also, I want to thank Ashley Robinson, who handled all the technical aspects of today's presentation. Thank you both. Without you, this presentation would not have been possible. So thanks again, Ms. Tia Banks. Thanks again, Barbara McIntyre. And thank you for joining us today. Goodbye.